so far as respondent number 8 is concerned. My lord, I was not present there. I was holding a press conference in Newtown. It's not an essential ingredient. On behalf of the contemners, Mr. Bandyopadhyay had concluded his submission.
নমস্কার, চলছে চলবে রণজিতে আপনাদের সবাইকে স্বাগত। আপনাদের ভালো রাখতে, সমাজকে ভালো করার প্রয়াসেই এই প্রতিবেদনের অবতারণা। কুণাল ঘোষ ঠেলাটা বুঝছে এবং আবার একটা জেল যাত্রার জন্য তাকে প্রস্তুত থাকতে হবে। রুল জারি হয়েছিল, শেষ খবরটা আপনারা জানেন না, এই গত 7 তারিখে আবার সেটা শুনানি হয়েছে এবং তিনি যেটা বলে পাশ কাটাতে চাইছিলেন, পালাতে চাইছিলেন রাদার আইটসে, যে তিনি সেদিন একটা প্রেস কনফারেন্সে রাজারহাটে উপস্থিত ছিলেন, ঘটনাস্থলে ছিলেন না। একটা ক্রিমিনাল কন্টেম্প্ট করতে গেলে ঘটনাস্থলে উপস্থিত থাকাটা ভীষণ জরুরি নয়। এই ঘটনাটা সুন্দরভাবে ইন্টারপ্রেট করছেন পার্থসারথী সেনগুপ্ত মহাশয়, যিনি ইনফর্মার হিসাবে, নট পিটিশনার, যে বিকাশ রঞ্জন ভট্টাচার্য, ফিরদৌস শামীম বা এই বিচারপতি বিশ্বজিৎ বসুর বিরুদ্ধে যেভাবে তারা স্লোগানিং করছিলেন, এটাকে ইনফর্ম করেছে কোর্টে এবং তার ভিত্তিতে সুমোটো সমস্ত ঘটনা দেখে তো তিনি পালাতে দিচ্ছেন না এবং আরেকটা তিনি বিপদে পড়তে চলেছেন এই কুণাল ঘোষ, সেটা স্পষ্ট হচ্ছে। আপনাদের একটু দেখাই। মাননীয় বিচারপতি ত্রয়ের এই বেঞ্চ যে ভীষণ সিরিয়াসলি এই বিষয়টা দেখছে। আগামী বৃহস্পতিবার 3:30টার সময় আবার শুনানি আছেন এবং ইনফর্মার হিসাবে আইনজীবী পার্থসারথী সেনগুপ্ত আবার তার পুরো বিষয়টা কনক্লুড করবেন। যদি এই প্রতিবেদনটা ভালো লাগে তাহলে লাইক, শেয়ার করে অনেক মানুষের মধ্যে ছড়িয়ে দেবেন। ধন্যবাদ।
On behalf of the contemners, Mr. Bandyopadhyay had concluded his submission.
Yes.
And supporting set or the others, they have adopted the submission of Mr. Bandyopadhyay. Now, my lord, what I submit at the outset is, my lord, once the rule is issued, my lord, I am the informer. I am neither the petitioner nor a party otherwise. I have informed the court that this has happened. Therefore, matter is now between the contemner and the court. And I can make submissions only if the court requires any assistance from my end. Otherwise, not. So that is the position of law according to me. Now, if your lordships feel that my submission will be of any assistance to your lordships, then I can try to assist your lordships.
Mr. Sengupta, we would like to require your take on this, on the technical maintainability point taken by Mr. Bandyopadhyay,
Yes.
and also on the involvement of respondent number 8, because the other respondents virtually they have apologized and said the context, maintainability and involvement. If you can throw some light on that.
Grateful to your lordship, grateful to your lordship. Lordships are dealing with this case. It's a great moment because some people are trying to undermine the dignity and majesty of the court. One, by humiliating one sitting judge of this court in respect of a matter where these persons were parties. And what we have done is simply we have brought it to the notice of the court. My lord, we can just see this is the situation. Go to
Section 15 বলেছিল, even assuming there is jurisdiction, suo motu cognizance could not have been taken under Section 15 in the manner it has been taken.
Yes. My lord, answer is very simple.
Yes,
Now,
Section 15.
in the case of a criminal contempt, other than a contempt referred to in Section 14, the Supreme Court or the High Court may take action on its own motion or on a motion made by the Advocate General, any other person with the consent of the Advocate General, or in relation to the High Court or Union Territory. Such law officer as central government may by notification the official get to specify in this behalf, or any other person with the consent in writing of such law officer. Now, my first submission on this is it the enabling power giving High Court the jurisdiction? My respectful submission is no, because the power comes from the Constitution itself. Constitution has clothed the Supreme Court and High Court. In my respectful submission, if not dealt with sternly, then it will only encourage persons not only to disrespect the honorable judges, but also
Sorry, please proceed.
Your Lordship sees the definition of criminal contempt. Criminal contempt means the publication, whether by words, spoken or written, or by signs, or by visible representations or otherwise, of any matter or the doing of any other act whatsoever which scandalizes, here it does not end, or tends to scandalize, or lowers, or tends to lower the authority of any court. So, this is broad enough to take within its ambit, or prejudices or interferes, or tends to interfere with the due course of any judicial proceeding. So, staging really a garrow before, in front of the chambers of the learned advocates who are appearing and shouting slogans.
আমরা rule issue করছি।
Your Lordships did not issue a rule on the first day. We had a conference of 2 hours.
He refuses to stand up. Just now he has stood up.
Possibly he has not heard what I say.
2010 HSSC 673.
That we have a copy already, don't we?
Please repeat the citation once.
No, this is 2010 HSSC 673.
2010 8 SEC.
We are also relying on this.
Correct.
So, Mr. Sengupta,
Yes, sir.
the way you are putting it, can you say this? That the Honorable Chief Justice, the affidavits were filed, those were captioned also as complaints. And there,
Yes.
suo motu rule was prayed for before the court's jurisdiction was sought to be invoked, that you issue a suo motu rule. We are not the petitioners.
Yes.
Those materials were before the court, and
Yes.
as is apparent from the Chief Justice's initial order assigning before us, that video clippings were produced, those
Yes.
affidavits were there. On these materials, Honorable Chief was of the opinion that this matter is serious, a bench should be constituted and place the materials before us.
Yes.
And then we also gathered further materials by seeking affidavits from the alleged containers. And after getting those materials on the first day, we did not issue a rule, as you said. And then it is this court which issued the rule for the first time
Yes.
after getting those materials, including the video clippings.
Yes.
So this can be governed by, arguably, by Rule 17, which does not confine it to the Chief Justice. It says
Yes.
rules issued by any court on its own motion shall be dealt with by that particular court. So the chief or the chief judge does is only constitutes our bench, assigns these materials to us, and leaves it on us to take a call as to whether we shall issue a rule of contempt. This is
Your
the
Lordship,
Yes.
yes, your Lordship has put it more precisely than I could. I was just drawing your Lordship's attention to the expression, notwithstanding anything. It does not mean
It's
that-
over and above. It's super additional. In
that's
addition.
right. That's right.
That's very.
Therefore,
And
Yes.
particularly since this is criminal
yes,
contempt. So
yes.
now under the new
Now,
provisions, it has changed. So
It has
no
changed,
difficulty.
yes, but not
Exclusively on the affidavit. If it's exclusively on the affidavit, then no. That is the distinction. No, he has not marked anything else. This is sufficient.
More judgment.
We're not citing any other judgment, Mr. Sengupta. Now on respondent number 8, you can just.
I just point out there are judgments cited by Mr. Bandyopadhyay, whether that should be distinguished or not. If your Lordship, these are all judgments, your Lordships will read it for advancing the.
Yeah, Mr. Sengupta, I don't think those judgments need to be dealt with.
Fine, I'm grateful to your Lordship.
Yes. Principles of law are fairly well settled.
Yes, so far as respondent number 8 is concerned. But what was the basic stand? My lord, I was not present there. I was holding a press conference before in Newtown. But it's not an essential ingredient of criminal contempt to be present in the place of contempt. I can commit criminal contempt sitting here while submitting before the court. So I was addressing a press conference. Is no ground to say that criminal contempt has not been committed. And I do your Lordship's kind attention, Section 2, subsection C of the Contempt of Courts Act, to say which tends to lure, tends to scandalize. This tends to is making it very wide. That is being staged and clippings of press conference were translated for the court. Not only one judge, a number of judges, aspersions were made.
Mr. Sengupta, shall we reassemble next week?
Yes, Lord.
Mr. Partho Sharathi Sengupta, Learned Senior Counsel, makes his submission
Okay.
on behalf of one of the informers. He does not conclude. Paragraph. List this matter once again on marked 3:30 p.m.